appeal, Taurus Petroleum Limited.
Lord Sumption will give the judgment of the court.
Taurus Petroleum Limited obtained in 2013 an arbitration award against the State Oil Marketing Company of Iraq, which has generally been referred to in these proceedings as SOMO. The present appeal arises out of Taurus's attempts, hitherto unsuccessful, to enforce the award against SOMO's assets. One of SOMO's assets was a debt said to be due to them under 2 letters of credit issued by the London branch of a French bank, Crédit Agricole. The letters of credit had been issued in order to secure the price of 2 parcels of crude oil which SOMO had sold to Shell. In March 2013, Taurus obtained an order that their award could be enforced as a judgment in England. They then applied for a third-party debt order against SOMO in respect of the sums due under the letter of credit. The effect of this order was to intercept payment to SOMO under the letter of credit and to require Crédit Agricole to pay the money instead to Taurus. At the same time, they obtained a receivership order. There are a number of essential conditions for the making of a third-party debt order, 2 of which are relevant in this case. The first is that the debt should be located in England. The second is that it should be owed to the judgment debtor, in this case SOMO. SOMO argues that neither of these conditions is satisfied. On the location of the debt, they argue that it was located in New York, because that was where the letter of credit provided for payment under the letter to be made. Normally, a debt is treated as being located in the place where the debtor is resident. Banks commonly have multiple residences according to the location of the branch which incurred the debt. If the normal rule applies, that will be London, the location of the branch which issued this letter of credit. But in a case called Power Kerber and National Bank of Kuwait in 1980, the Court of Appeal held that there was a special rule for letters of credit. The debt due under a letter of credit was said to be located in the place of payment. The Court of Appeal in this case was bound by the earlier decision in Power Kerber and held that the debt being located by that test in New York, the English court had no jurisdiction to make a third-party debt order. The Supreme Court unanimously allows the appeal on this point. In their view, Power Kerber was wrongly decided. There is no reason why debts under letters of credit should be subject to any different rule regarding their location as other debts. Turning to the question whether a debt was owed to SOMO, the argument is that although SOMO was identified as the beneficiary of the letter of credit, the money due under it was not owed to them. This is because the credit provided that payment was to be made to the Iraq Oil Proceeds Account, which is an account of the Central Bank of Iraq at the Federal Reserve Bank of New York. The account is part of the mechanism by which Iraq's oil revenues were applied to development in Iraq and to reparations to Kuwait, pursuant to the United Nations sanctions regime inaugurated in 2003. Under the terms of the credit, Crédit Agricole made a direct promise to Central Bank of Iraq that it would pay in accordance with this procedure. The question is whether that provision made Central Bank of Iraq the true debtor under the letter of credit instead of SOMO. By a majority of 3-2, the Supreme Court holds that SOMO remained the debtor under the letter of credit. The effect of the clauses in favour of Central Bank of Iraq was to create a collateral obligation in their favour as to the manner in which a debt due to SOMO would be discharged. The reasons are stated in a judgment by Lord Clark and in concurring judgments of Lord Sumption and Lord Hodge. Lord Neuberger and Lord Mance write dissenting judgments on this point. It follows that the third-party debt order was properly made and that the present appeal must be allowed.